from date list for judgment item 1, second appeal 190 of 2003 along with item 2.
Both the appeals are dismissed.
From supplementary list case item 4, second appeal 70 of 2023.
Yes, please.
May start.
No, I will not permit any request. If you want to start, you start.
I start.
I've heard you enough.
Yes.
I've already recorded that I am not satisfied. What else do you want to say?
I would just record some facts.
No,
From
no facts are required. We have read it fully, full text we have read. We have heard you half an hour yesterday.
Exhibit A that we had exhibited was of the date 24/12/2008.
Exhibit A. That we have seen?
Yes.
Yes.
And
What is your substantial question?
my substantial question of law is
Which one? Tell us. Yes, please. Which one is your substantial question of law?
at page number 3, point number 4, I would be expanding on that point.
Well, that I have heard you. I have heard you on this only yesterday.
My case would be that Exhibit 3 is rent receipt for the month of May 2008. Exhibit 3 by M is the
Rent receipt for
May 2008.
Exhibit 3.
3.
May 08.
May 08.
Yes.
Exhibit 3 by N is November 2008.
November
2008.
2008.
Then the Exhibit A that I have exhibited is the advance payment of ₹10,000.
Exhibit A.
Yes.
Exhibit A.
That has been exhibited by the defendant.
Advance payment of
₹10,000.
10,000.
That was paid on. It is dated 24/12/2008.
24/12/2008.
Which the plaint describes the period of default at point number 5 to be from the month of May 2008 to December 2009.
Yes.
If we calculate the number of months that comes, excluding November 2008, for which Exhibit 3 by M stands, the number of months comes to 17 months. The rent that has been fixed as per the rate is ₹500 per month. My case is that this eviction suit was filed on one of.
Why did you exclude November?
My case is that the Exhibit B to B by 4 are the rent receipts for which I have paid the rent in the month of 2008 for the intervening period.
B to B by?
B to B by 4.
Which period is this? Which period is this?
It corresponds to 2008. That is
which period?
In between. That is from
In
July.
between means how, from where to be getting?
That I cannot say.
During the default period. It relates to during the default.
During the period of the plaint has been filed.
That's all, we have heard you enough.
The plaint has been filed on 29th January 2010. My case is on the date of filing of plaint.
Yes.
I was not a reporter, and for that I have a judgment of the Honorable Supreme Court.
What judgment is that? What judgment is that?
This is 1998.
Nineteen 98.
Volume 3.
Volume?
3.
Yes.
SCC 58. Wherein in a similar.
Yes, what is it?
In this case, the tenants had sent a bank draft for the entire arrears before filing of the suit. And on that fact, the court held that on the filing of date, the tenant was not a defaulter. And on that ground, the Honorable Supreme Court has allowed the appeal. It was all, the tenant had sent the same amount by a bank draft, and that was encashed by the landlord, meaning therefore that it was received, which is also the case in the present case. The amount was received, it has not been disputed. The Honorable Court says in paragraph 8, we fail to appreciate how this contention can be pressed into service on the peculiar facts of the case. As we have seen earlier, the eviction proceedings have themselves become infructuous once the bank draft dated to 1989 for the full amount of arrears was already got encashed by the respondents' landlords. In this present case, the eviction suit was filed as per the date on 29/1/2010. The advance rent was of 24/12/2008. On the date of filing of the eviction suit, there was no arrears to my name, and as such, the eviction suit was not maintained, as it was already announced.
What is the finding with regard to Exhibit A? What is the finding with regard to Exhibit A?
Not the appellate court says.
Who asked you to intervene?
As well as-
You will intervene as per your suite will.
No, sir.
You were not there. At your instance, this case was adjourned for today, and you remained absent.
As well as-
कौन सा तरीका है? किसी कोर्ट में होता है सर, दूसरा कोर्ट में नहीं हो सकता। सब कोर्ट में आप ऐसे घुस जाते
नहीं,
हैं।
ऐसे नहीं घुस रहे, हमको
Sir, I'm not.
Yes.
Not.
What is the finding with regard to Exhibit A? Exhibit A is this document. No, what is this document? 10,000.
This is the advance payment receipt.
This is Exhibit A.
Exhibit A.
What is the finding in connection with Exhibit A?
Page 51 of the trial court judgment.
Page 51. Yes, and then
On the last 4 lines. On the other hand, testimony of PW1 defendant tenant in para 9. It has been stated that on dated 24/12/2008, plaintiff took rupees 10,000 from the government which were used in adjustment of areas of rent. Defendant also identified rent receipts which have been marked as Exhibit A by this court.
What is exhibit? Exhibit A is advance payment, no? This is not rent receipt.
This is the advance payment which were used in adjustment of areas with rent.
This is the rent receipt of exhibit A is the
Is the
rent
advance
receipt.
payment receipt.
But has also identified the rent receipts which have been marked as exhibit A.
Lump sum payment.
What about the appellate court? Appellate.
Page 33. The defendant has not paid rent in respect of suit property to plaintiff respondent from
With
the
page
month-
number?
Page 33.
30.
Internal page number 26. The appellate court judgment.
Yes, 33.
The defendant has not paid rent in respect of suit property to plaintiff respondent from the month of May 2008 to May 2009. That paragraph. The last 5 lines. I continue. In spite of repeated requests of payment made by the plaintiff respondent, the defendant appellant has made himself defaulter in the eyes of law. The plaintiff respondent has filed 20 counterfoil rent receipts and they have been marked as Exhibit 3 to 3 by S in the series. The counterfoil of the rent receipts from the month of May 2008 onwards has not been filed and it has been stated that defendant appellant defaulted to pay the rent from the month of May 2008 to December 2008. In this regard, the PW1 brief Narayan Singh details the defendant appellant tenant stopped paying the rent onwards and despite being requested for, he did not pay the rent. On the other hand,
Second appeal number 70 of 2023. Appearance default. The learned counsel for the appellant has submitted that the period of default in the present case, as alleged in the plea, was from May 2008 to December 2009. The case was filed. The suit for on account of default in payment of rent. There is no other ground.
it is grounding of personal necessity. Which was
Okay, personal necessity is also there. Okay, this is on the point of default.
it has been filed by a co-owner of the property, co-sharer of the property. That has not been shown that the co-sharer, co-owner can evict the suit property on his own, the entire suit property on his own, especially given the fact that he was only 1/7 shareholder of the
Who was the entire premises was let out to you, no?
It's a big property, it is part of it, that is 1000 square feet. Part of it has already been.
इसको जरा देखिए. The suit was filed on 29/1/2010. He submits that an advance on account of rent was paid by the Exhibit A to the extent of rupees 10,000 on 24/12/2008, and therefore on the date of filing of the suit, the defendant was not in default in payment of rent. He has relied upon the judgment of the Honorable Supreme Court reported in bracket 1998 bracket close 3 SSC 58. The learned counsel submits that once the arrears of rent is accepted at a later point of time, prior to filing of the suit on account of default in payment of rent will not cannot be decreed. Personal necessity. Where is the finding of personal necessity?
in page number 34, internal page 27 of the appellate court judgment.
34.
Plaintiff requires the suit property to meet his bona fide necessity for his house, since the house in which the plaintiff respondent is at present residing is of one room. His family consists of plaintiff himself, his wife, and 3 sons. Plaintiff now intending to get his eldest son married, and he requires the suit property for his sons for residential purposes. PW1 defendant himself stated that it is in knowledge of the plaintiff that the suit property is totally damaged, and it is not up to the level of any kind of accommodation, and that is why the claim of plaintiff that he requires property is totally light. The defendant has not produced any evidence which shows the plaintiff has no need for suit property. It has relied on my statement to approve the plaintiff's case. It has to stand on his own case. Hence, this point of determination number 3 is decided in favor of plaintiff.
So where is your case of 1/7 share, 1/6 share?
Share has come. It has. Let's be kindly proceed with plaint because.
Where is it mentioned?
Page 24, internal page 17, the rent.
Where is it mentioned?
That the rent receipt, the evidence of
No,
rent.
not the rent receipt. We are on personal necessity. Where was your plea that it is 1/4 and therefore he is not entitled for entire eviction? Where is your plea?
Page 12. Let's become at page 9, para 2. The plaintiff's case in brief is that the plaintiff is the owner of the suit property, which originally belonged.
No, that you narrate your case. Where is your objection to this?
My objection starts from page 12. From bottom 8th line, page 12. As far as the defendant is aware, the Schedule A property is the property of Motilal Sahu, Narayan Sahu, and Gangadhar Sahu, all being sons of Koduteli, each having equal share and stamps recorded in the name of Al Survey of 1972-73 under Khata number 21. In remarks column, illegal possession of Ram Pare Singh, son of Munni Naz Singh.
So you are trying to raise a title dispute. He was the person to whom you used to pay the rent. Under eviction suit, the title dispute cannot be decided. What will be the portion? Did you enter into agreement with all the 7 owners of the property? Did you enter? Who was your tenant? Who was your landlord? All 7 persons were your landlord, or there was only one landlord? One landlord.
He was authorized by all the co-sharers to collect rent. That is this.
From where do you get this?
That has come in the.
The learned counsel has further submitted that the suit property belonged to as many as 7 co-sharers. As many as 7 co-sharers. And therefore, the plaintiff himself could not have asked for eviction of the entire suit property on account of his personal necessity.
He admits that he is the co-owner of it.
And he
That
has
is
admitted that he is the co-owner of the property. He submits that this aspect of the matter has been ignored by the court by decreeing the suit on account of personal necessity as well. You have to add anything to it, Mr. Das? These are the only submissions, two
These are the
submissions.
two. Firstly, so regarding personal bona fide necessity, there are two grounds, Lordship. First, Your Lordship, that he being a co-owner, Lordship cannot claim for personal bona fide necessity of the suit. That is one. Two, Your Lordship, the court will has to explore the possibility of partial eviction.
That has been
That is-
explored.
Lordship, just by saying that he has a large number of people, Lordship, they are not. If they are staying in one room, the entire family as he has claimed, then he may not require 1,000 square feet for the as an addition.
You are living in an area of 1,000 square feet, which is a constructed area.
It is a constructed area.
1,000 square feet.
Yes, can we see the schedule, Your Lordship, of the print?
1,000 square feet is just 3 BHK.
3 BHK, and he says I am staying in 1 BHK.
Yes, not 1 BHK. He is staying in one room.
One room.
Yes, he wants one room for his for his son's wedding.
Yes,
They
one
want
room.
a separate room, don't they?
Yes, and he may not have a right to a separate room because there is one more additional development which we have brought by your supplementary affidavit, that later on the co-sharers have sold their shares to me. That also we have brought on record. Yes. Now, Your Lordship, take into consideration that the finding with respect to default is Lordship erroneous on the face of it, Your Lordships. Had the payment been made during the pendency of the suit, Lordship, matter would have been otherwise. Much before institution of the suit, there was no default. That was a false allegation. And he did not even mention it, but he acknowledged it when Your Lordships confronted on the evidence. They did not come further on that.
If you have become, sorry, how have you become the owner of the remaining property?
Lordship, you kindly say we have filed an affidavit.
The relevant portion of the registered sale.
Yes, in that certificate only we have annexed, though we have mentioned relevant portions. The substituted appellant has the Lordships filed the purchase date, Your Lordship, during the
When was it purchased?
It was purchased recently. It was purchased in 2011 during the pendency of the suit.
So why did you bring it on record?
Lordship, we had filed a separate suit for declaration, Your Lordship, that he cannot now maintain the suit.
Relationship is otherwise admitted.
Relationship of the
Is otherwise admitted. There is no problem.
yes, because we were tendering rent and we have also produced the rent receipt.
Right.
Relationship is admitted, default is Lordship denied, and that is the finding is Lordship contrary to the law. And secondly, personal bona fide
Okay.
necessity. Yes, these are the two.
After hearing the counsel for the appellant, this court finds that the suit was filed for on account of default of rent, payment of rent, and also on account of personal necessity by Deep Narayan Singh. The relationship of landlord and tenant between the parties is not in dispute, and no such dispute has been raised.
Also, we
Even
have
during
only
the
said
course
that
of
you are the person authorized on behalf of the co-sharers to collect the rent. He is not the exclusive vendor. So in the print, they have stated that they have also stated that I am filing it as a co-owner only.
The it appears that the plaintiff had also claimed himself to be the co-owner of the suit property. Who had and claimed the suit property and claimed that the suit property originally belonged to one Satish Chandra Shah, who sold the same on 29/8/1969 to the mother of the plaintiff, and after her death, the same suit property devolved upon the plaintiffs and other co-sharers. And the defendant was inducted as a month-to-month tenant under the plaintiff in respect of the suit property at the rate of ₹500 per month, and the rent was being paid to the plaintiff. The learned trial court, while considering the point of default, has the learned trial court decided the issue number 4 as the point of default, the period of default being for the month from the month of May 2008 to December 2009, and also whether the defendant was in arrears of rent. The learned court referred to the evidence of the defendant that on 24/12/2008 the plaintiff took ₹10,000 from the defendant, which were used in the adjustment of arrears of rent, and the defendant also identified the rent receipts. Exhibit A is only advance payment. That is not the rent receipt. Advance payment कैसे होगा?
500
Any
रुपया महीना
period
है.
mentioned? Any period mentioned?
No period mentioned.
Is it a rent receipt or it's
It
a?
is bearing the signature of the plaintiff.
That's right.
Yes.
Advance payment is not the rent receipt. You have got exhibit A.
Lordship,
And
one
also
thing.
gone through, and the learned court
Only
had
one
also.
thing. If the Lordship goes through that judgment.
I'm just waiting.
No, just why they say advance and sometimes they say lump sum. Lordship, May to November, May, June, July, August, September, October, November, 7 months, 3,500 would have been the due, and we have paid 10,000. Therefore, part of it was towards the adjustment of the areas which were due, and rest was advance payment. And thereafter, next month again they took the payment. That receipt they have also brought on record. So, Lordship, if there was a dues in prior to Lordship November, then naturally they will not issue a receipt for December unless that previous dues are cleared. They will issue a receipt for November, May, June, that way. And they have also acknowledged the receipt, Your Lordship, for subsequent period.
That is exhibit B.
Lordship, they have
B to B/4.
B to B/4 and yes. In fact, if Your Lordship sees exhibit 3/M also, is the receipt for the November 2008 and December 2000, and thereafter Lordship may see 3/O, all payments subsequent of those rent receipts they have filed, Your Lordships.
B to B/4 is for which period? Your junior is unable to respond to
I'm
this.
just showing you. So B to B/4
Is
is
for which period?
B to B by 4, your lordships, are the receipts for the subsequent period from December 2008 to, your lordships, to subsequent periods.
During the course of arguments, the learned counsel for the appellant has submitted that the exhibit B to B by 4 were rent receipts issued for the period from December 2008 onwards. The learned trial court has considered the exhibit A, and with respect to exhibit B to B by 4, the learned court recorded that there were overwriting in that document and accordingly rejected the same. Paragraph number 12 ka, the finding is as follows, page number 12 of the trial court judgment. The finding of the learned trial court is as under. So far as the point of personal necessity is concerned, the learned court discussed the findings as under issue number 5. So far as the learned first appellate court is concerned, the learned first appellate court also held that the defendant has defaulted in payment of rent for the period from May 2008 onwards to December 2009. And also upheld the finding of the learned trial court on the point of personal necessity. This court is of the considered view that the default in payment of rent and the ground of personal necessity are two distinct grounds altogether. And if even one of them survives, the tenant is liable to be evicted. So far as the point of personal necessity is concerned, this court finds that both the courts have given concurrent findings with regard to personal necessity of the plaintiff, and the argument of the appellant that he was not the owner of the entire property and therefore the ground of personal necessity and therefore he could not have been the appellant could not have been evicted from the suit premises on account of personal necessity is not tenable in the eyes of law. So far as the point of default is concerned, the learned court has is believed Exhibit B to be by 4, which according to the counsel for the appellant was for the period December 2008 onwards. This court is of the considered view that the point regarding default as well as personal necessity in the present case are essentially questions of facts. No substantial question of law arises in this case. Accordingly, this appeal is
Suppose
dismissed.
default the principle which the State Court has observed, Your Lordships, that is contrary to the Honorable Supreme Court statement.
That I noted, your judgment. I distinguished it.
No, because
I'll take care of this. That is why I'm not
why
saying.
I am telling for the reason there are two directions. One is eviction and second is areas of rent. If Your Lordship is satisfied because they have not disputed that receipt of 10,000 rupees, then also that part has to be modified. I cannot be made liable to pay. There may be a ground of eviction sustained on the ground of personal bona fide necessity. But areas of rent which have been directed to pay. But only one observation at the end, if it is possible, that these findings will not affect any other legal proceeding pending between.
Why should I? It is simply, you see, these are absolutely under BBC Act.
That
It's
part
summary
observation in
proceedings. No
because
observation is required. No observation is required.
Lordship only mentioned that these findings are confined to the present proceeding.
Naturally, it has to be
Because we have a
confined.
sealed it in our favor now.
Sorry?
We have a sealed it in our favor now.
That's
We have
right.
filed a separate title suit.
You see, the moment execution is filed, you can say that only to the extent of 1/7 you can be evicted. Maximum. Because he has not executed a sale deed to you.
He has not executed, but
Right.
Lordships, the decree has to be executed in the to the extent if there is an eviction decree.
Even at the stage of eviction decree, you can file your objections. There is any bar? There is no bar. Isn't it? There is no bar. You can
No, no.
still go ahead.
Also, there are
At the
judgments
stage of
against me.
execution.
Also, the consular may say that the executing court will not go into this once it has been held that I am entitled for. Decree cannot be modified or cannot be read differently by the executing court. So only one, but somehow not I am saying directly. Lordship will say that these findings are confined to this proceeding the BBC Act. Somewhere else, so that will protect my interest.
At the at this stage, the learned counsel for the appellant has submitted that the dismissal that that it may be observed that the findings of the court concerned would be only in connection with the proceeding under BBC Act. There can be no doubt that when a proceeding is initiated under BBC Act, the findings recorded therein are confined to the provisions of the
Yes,
BBC
that will.
Act.
From date is fifth case attempt 24, second appeal 446 of 2017.
But the appellants here plaintiff.
Appellants are the plaintiffs.
Yes. So they were dismissed. And appellate court has affirmed the findings in the judgment of the trial.
Sorry.
Appellate court has affirmed.
Yes.
First of all, Your Lordship, I would like to show what was the suit in this particular case. Number of my lord the khatas and my lord have some very land, Your Lordship. Parties are wrong. So these are all my lord this where the suit property. So far as the plaintiff, Your Lordship, is concerned, plaintiff, Your Lordship, has come for a declaration of my lord title and for my lord confirmation of possession, and he found recovery of possession. My lord, the claim of the plaintiff, Your Lordship, is based on my lord the agnatic relationship as per the customary law in the trades, their norm. But my lord, here my lord, in this particular case, both the parties, your lordship, the plaintiff as well as the defendants, both are claiming that they are agents. The property, your lordship, the property belongs to one Bujwa Ram. And my lord, the facts of the case, your lordship, that one Hela Ram, your lordship, our case, your lordship, is that he had two sons, Sarua and my lord Bujwa. And my lord, one another son, your lordship, through whom they claim, my lord, the defendants claim, is Harua. My lord, our case, your lordship, is that his father, my lord, was not a biological son of my lord the Hela. My lord, when the marriage, my lord, second marriage was done, my lord, then my lord, the mother, my lord, has come along with the, my lord, the boy. So the case, your lordship, of the plaintiff, my lord, is that Hela Urao has actually two sons, and my lord, admittedly, being my lord the and Bujwa Urao, your lordship, died. So my lord, we are claiming the property by agnatic relations. My lord, the case of the defendant, your lordship, is that
You are the plaintiff. You are the descendants of Bujwa.
no, I am the plaintiff of Surva.
Suruma. What is Haruna? Harua?
Harua is the another son. So far as for that, we are saying that he is not a biological son of the Hela.
You are the descendants of Sarua.
Sir, Bujwa died.
Just a moment.
Well,
Harua claims the property.
Harua, descendants of the Harua claims.
Okay. They are
And
the
contested-
defendant.
They
They are the defendant.
They are the plaintiff.
Harua is the plaintiff.
Harua is the defendant. The descendants of the mother Harua is they are the defendant.
Descendants of Harua are the defendant.
Defendant.
Okay.
Their claim, your lordship, is so far as the biological son issue of biological son, your lordship, is concerned, that my lord, they are the natural son. What is their stand? That all the Hela had three sons. That is what.
How does that make a difference?
My lord,
How does that make a difference?
it does make a difference.
How?
My lord, if suppose my lord,
No, when you are saying customary law, what is the evidence?
evidence are there, but
Evidence that if there is a mother who already has a son from first husband or wherever,
those evidence has come.
no, even if it is there, whenever a wife comes in the family as a wife and comes with a child,
No, the child is from some
Maybe.
previous.
maybe. So he will not have any right
No, that will have no. He will have no.
in the family of his new father.
Yes, that what is the case. Our case is that he has no right as per the
Customary law.
customary law
What
or
is the
even otherwise.
Otherwise means, when once you say customary law, we will not look at any other law.
No. I am confined to customary law.
What is the evidence that such kind of person will not inherit anything?
We have stated that they are governed by the plain bullet. They are governed by the custom.
So what is the custom that you have pleaded
Yes.
and proved?
That is one of it. Let me conclude. That is one of the issues. Both the courts have said that he is a biological son. Several other documents the court has also relied upon some documents. My lord, my substantial question of law, your lordship, is that my lord, the core issue in this matter, your lordship,
Just a moment. The learned counsel for the appellant has submitted that the plaintiff has lost in both the courts and is the appellant in the second appeal. He has submitted that the property stood recorded in the name of Hela Urao.
Hela. Property was the property which we are claiming by virtue of this suit.
Yes.
It is in the name of Bujwa and in the name of some of the Havardar also, which is a Bonieri land. So that let me, my lord, just I won't take much time. My lord, both the courts below you could not appreciate the, my lord, that there are other properties apart from, my lord, the RS Khata number 18. Entirely confined, entire whole the judgment, my lord, both the judgments your lordship has been confined only to the point that, my lord, it is a RS Khata 18 only, which was finally prepared way back in 1935. So those things now you cannot come across. My submission before your lordship, both the parties your lordship are claiming that they are the agents. He is also claiming I am the agent. I am also claiming, my lord, I am the agent. Now the question arises.
I'm not able to get it what you are saying. How both will claim that they are the
Yes.
agents?
And
Because this Sarua also has got some descendants.
so far as Sarua is concerned, I am appearing on behalf of the Sarua.
Ujjwa also has got some descendants.
Ujjwa died. Ujjwa died.
Issueless.
And there was a son who died issueless. My lord, and his granddaughters, he had 4 granddaughters, out of 4 died. Those things are in the genealogy. There was one daughter that is also there. But, my lord, the claim of the defendant,
नहीं आप इस तरह से नहीं, इतना सारा facts आप इस तरह से नहीं बता सकते।
नहीं, हम हजूर को हम इसमें थोड़ा सा
हमको
ज्यादा
एक-
समय नहीं देंगे।
नहीं ज़्यादा समय इतना में तो हम सेकंड अपील सुन रहे हैं लग रहा है हमको।
नहीं,
आप हमको बताइए
हम
there are
इसमें एकदम
concurrent
कोर इशू पर हम जा रहे हैं।
Yes, tell us. What
इसमें
is the point?
सच्चाई ये है
Core
कि इसमें दोनों कोर्ट इस पॉइंट को समझेंगे।
लगता है हम
हाँ,
नहीं समझ पाएंगे।
नहीं ये समझेंगे
इसको बहुत
और
ज्यादा
एक
possibility
जनरल टाइप का ऑर्डर
जब
करेंगे।
आप दो विद्वान जजों को नहीं समझा
नहीं,
पाए,
हम
तो कैसे समझाएंगे?
हम प्रयास करेंगे। I can only try. इसमें हमारा समझ से हजूर हमने इसको गहराई से इस केस को देखा है। इसमें जो मेन इशू है कि एग्नेट है कि नहीं है, वो तो फ्रेम भी नहीं किए। ऐसा हाउ इट कैन बी कि बिना कोई इशू फ्रेम किए आप उस पर आप जजमेंट दे दिए। ये वन ऑफ द सब्सटेंशियल क्वेश्चन है, इसको देखा जाए।
इसमें 71 का भी प्रोसीडिंग हुआ है।
प्रोसीडिंग पहले हुआ
उसके फेवर में
वो उसमें हम हार गए थे, उसके बाद अपील भी हुआ था, उसमें भी हार गए थे, उसके बाद सूट आए थे।
तो 71 के बाद सूट का क्या स्कोप?
तो इसलिए कि दोनों पार्टी ट्राइबल है। इसमें ट्राइबल केसेस में तो रेस्टोरेशन का कॉन्सेप्ट 71 ए में नहीं है।
वो विदाउट जुरिसडिक्शन था ऑर्डर।
नहीं, वो ऑर्डर इन्होंने कहा दिया था
71 ए में दो ट्राइबल के बीच में भी हो सकता है 71।
नहीं,
इज देयर एनी लीगल बार?
बारी नहीं हजूर, इसमें जो है ना कि अगर कोई वैसा ऑक्यूपेंसी रैयत अगर हो, अगर और 71 ए में अगर जैसे इशू ऑफ टाइटल है जैसे, तब तो डिसाइड नहीं वो पॉइंट पर उनका कहना ठीक था। और इस पॉइंट को भी ये कोर्ट ने नहीं समझे, कह दिया कि नहीं आपका बार्ड बाय लिमिटेशन है। दोनों कोर्ट कह दिए। हजूर का जजमेंट है, हम इसमें जजमेंट देखे ये मोहनी अहीर का जजमेंट हजूर इसमें आया, माय लॉर्ड का जजमेंट है, जिसमें सेक्शन 14 को हजूर ने कंसिडर किया कि रेवेन्यू प्रोसीडिंग्स वगैरह में अगर अर्लियर प्रोसीडिंग हुआ है तो वैसे केसेस में आप वो बार्ड बाय लिमिटेशन नहीं। हमारे भी एक केस में हजूर ये पॉइंट हमने रेज किया था कि नहीं 14 नोटिंग का ग्राउंड इसमें नहीं चलेगा सूट में, लेकिन माय लॉर्ड ने मेरे केस में भी कहा कि नहीं वो सब्सटेंशियल क्वेश्चन। तो इस पॉइंट पर तो इनका एकदम गलत फाइंडिंग है।
नहीं, आई एम नॉट एबल टू
ना हम इसमें
ऐसे बिना समझे क्वेश्चन ऑफ लॉ तो
नहीं, हम इसमें से
नहीं, आप नोट्स बनाते जाइए।
हम दो ही 3 पॉइंट हम बहस करेंगे। पहला पॉइंट तो ये
So
कहेंगे
you are jumping from one point.
No, I'm not.
आप एक substantial question of law पकड़िए।
हम एक सब्सटेंशियल क्वेश्चन ऑफ लॉ ही पकड़ रहे हैं।
बताइए कौन
पहला
सा
सब्सटेंशियल
अब
क्वेश्चन
पहले
ऑफ लॉ।
बताइए कौन सा substantial question
Yes.
of law? Which one are you referring?
Yes. Yes, my lord, it is, my lord, at page 12, my lord,
मतलब
D.
IJ कितना का substantial question of law बनाया?
D. whether the learned appellate court while passing improved judgment and decree committed serious error of law, as it completely failed to appreciate that the issue with regard to agnatic relationship with Bhuchwa was not framed. This is the core issue with respect to the entitlement over the schedule A property. जो मेन जो की डिस्प्यूट है, अगर कोर्ट ने इनको मान भी लिया कि नहीं, ये भी अगर मान लीजिए हेला और के अगर लड़के थे, इनका भी शेयर है जुआ, तभी हमारा तो टोटल खत्म नहीं होगा। अगर मान लीजिए हम भी सन है, ये भी सन है, तो एग्नेटिक रिलेशनशिप कौन एग्नेट है कौन एग्नेट नहीं है, किसका क्या शेयर होगा नहीं होगा, इसको बिना सोचे समझे टोटल डिसमिस कर। एक तो ये एस्पेक्ट है। दूसरा, दोनों कोर्ट ने कह दिया कि आपका सूट बार्ड बाय लिमिटेशन है। सूट बार्ड बाय लिमिटेशन अगर होने का सवाल इसलिए भी नहीं होता है कि 71A के अपील के बाद 2000 में
सूट में they have said that with regard to questioning the entry in record of rights, उसी पर सूट टाइम बाद
नहीं, एंट्री इन द रिकॉर्ड ऑफ राइट तो क्वेश्चन है ही नहीं।
ये इशू नंबर 9
इन्होंने फ्रेम कर दिया। हमारा क्या प्रेयर है जो देखा,
आपको बिना सुने इशू फ्रेम कर दिया क्या?
इशू तो हजूर कोर्ट बहुत सा फ्रेम कर रहा है। और कुछ
इशू नंबर 9 was framed,
I agree,
and that issue has been held to be barred by
that issue that your lordship may kindly
correction in entry of record.
may kindly appreciate that issue only pertains to khata number malad RS khata number 18 only. Apart from that, there are several other khatas also that
Which
is
all are the khatas?
yes.
और कहाँ से मिले?
अब हम दिखा देते हैं। Yes. A प्रॉपर्टी हम पढ़ देते हैं। शेड्यूल ए इज खाता नंबर 18, जो कि एक खाता हमने अभी कहा। दूसरा है आरएस खाता नंबर 178, 177, 176, 175, 104, 184, 183, 65, 128, 129,
They are plot numbers
174.
or khata number?
But
They are plot number.
these are khata number, and there are several plots here. वो सब प्लॉट पर तो मतलब बात भी नहीं थी हुजूर। सिर्फ 18 पर ये कह करके इसको उसका एंट्री 35 में था। अच्छा, इसमें कितना बुनियादी लैंड है, बुनियादी लैंड को भी कह रहे हैं कि उसका सारा जो खेवटदार सब एक्सटिंक्ट हो गया, तो वो सब में जो लिविंग खेवटदार है उसी के थ्रू जाएगा। तो गवर्नमेंट में भेस होता नहीं।
तो लिविंग कोई
लिविंग
खेवटदार
में हम
बचा है
हैं,
तो कहाँ
लिविंग में हम हैं। अच्छा, ये बात इन्होंने एडमिट भी किया। दैट इज आल्सो वन ऑफ द सब्सटेंशियल क्वेश्चन ऑफ लॉ। उस पर भी मेरा सूट डिसमिस कर। जब अगला पार्टी ये चीज एडमिट कर रहा है कि नहीं इसमें इनका जो है सो इसी के ये उत्तराधिकारी अकेले उत्तराधिकारी हैं, तो कम से कम उस सब पर तो सूट डिसमिस नहीं हो सकता है। हम ये पॉइंट हम फ्रेम किया, देखा जाए। Malord I में हमने फ्रेम किया है, whether the court below have failed to take into consideration the defendant number 1 Mangaura, who is the defendant number 4 in para 84 of the cross examination of that Kevat number 12/5, 12/4, 12/5, 12/6, which are the nearest Kevatdars of Dhukua and Sarva, died issueless, and the plaintiffs are only successors of them. इन्होंने डिफेंडेंट नंबर 1 का गवाही में एडमिट किया है। उसके बाद कम से कम उस सब प्लॉट पर तो उस सब खाता पर तो हमारा सूट कैसे डिसमिस हो सकता है? दोनों कोर्ट इसको नहीं समझे, तो दोनों कोर्ट इसको इस बात को नहीं समझे, और वो भी पॉइंट हमने फ्रेम किया है। ऑर्डर 41 का पॉइंट भी हमने फ्रेम किया है। Paragraph C में कि whether the learned appellate court being the final court of fact and law was duty bound to exercise the jurisdiction vested in order 41 rule 33 of CPC and would have arrived at an independent finding that that of the learned trial court and assigned reasons for the same for affirming the trial court judgment. तो ये मसला हजूर, इसमें जो भी फाइंडिंग्स आई है, एक सिर्फ सेक्शन 18 के बुनियाद पर ये इसको कह दिए दोनों कोर्ट की आपका लिमिटेशन सबार्ड है, दैट इज आल्सो ए परवर्स फाइंडिंग, दैट इज इशू ऑफ लिमिटेशन पर भी हमने फ्रेम किया है, जो वो भी इशू इसमें है। इसके अलावा जो हमारा बाकी जो लैंड्स है जिस पर कि हम लाए थे, उस पर भी इन्होंने इसको नहीं माना और वो उसको तो बिना समझे नहीं माना। और दूसरा जो कि लैंड है जो जिस पर हमने हुजूर को दिखाया, तो उसमें भी अगर मान ले भी कि अगर ये अगर बायोलॉजिकल सन है, तो बायोलॉजिकल सन है तो मेरा कुछ शेयर कम हो सकता है, मेरा टोटल टाइटल कैसे एक्सटिंग्विश हो जाएगा? टोटल टाइटल तो मेरा एक्सटिंग्विश नहीं होगा, इनका भी होगा, दैट आई एग्री, हाफ हो सकता है, अगर इसको माना जाएगा तो हाफ इसका भी हो सकता है, हाफ मेरा भी हो सकता है। टोटल टाइटल्स
What was the earlier title suit? 226 of 1934.
वो ये एक डॉक्यूमेंट लाए हैं जिसमें सेक्शन 18 के बिहार में ये भी इनका क्लेम कॉन्ट्राडिक्टी है, जो कि हम ईवी केस लाए हैं। एक तरफ तो ये कहते हैं कि हम हेला के सन हैं और दूसरे तरफ ये कहते हैं कि नहीं 230 वो टाइटल सूट के बुनियाद पे जब हम लोग का रेंट पे नहीं हुआ था, तो रेंट पे के बुनियाद पर इसमें ऑप्शन परचेज वगैरह हुआ, उस कंडीशन में उनको एक्सक्यूशन में वो प्रॉपर्टी सेक्शन 18 में मिला, उसी के बुनियाद पर इसमें एंट्री हुई। ये चीज ही कर रहा है, ये चीज कर रहा हूँ, दैट इज विद रेस्पेक्ट टू ओनली 18, ये सिर्फ उतना ही 18 के बारे में। तो इनका स्टैंड खुद भी कंट्राडिक्टरी है, एक तरफ एग्नेट के तौर पर हेला के सन के तौर पर क्लेम कर रहे हैं, दूसरा तरफ ये एक्सक्यूशन ऑफ डिग्री और ये सब के बुनियाद पर क्लेम कर रहे हैं, इनका खुद भी कंट्राडिक्टरी स्टैंड है। प्रोबेट का लॉ कहता है जो कि ऐसा नहीं कर सकता है, ये चीज भी हमने फ्रेम किया कि whether the learned appellate court while passing into judgment and decree complete fail to appreciate that defendant 1 and 2 cannot be allowed to claim suit property as being descendants of Haudura at the same time to claim by virtue of auction purchase in CS khata.
Just a moment. You are referring to.
Well, I am referring to B.
Just.
Substantial question of law B हम रेफर करेंगे।
ये जो आप you say that the entire property, they have dismissed your case with respect to the entire property relating to khata number 18,
yes.
and rest of the khata numbers have not been taken care of.
Not
After page number 53 and
page number
50.
53. Appellate.
Running page. आपका दो शेड्यूल है, एक शेड्यूल ए है, एक शेड्यूल बी। शेड्यूल बी इज in connection with CS खाता, राइट? CS खाता का जो प्लॉट्स उसमें दिया हुआ है, एंड शेड्यूल ए इज द RS खाता। So therefore,
उसमें भी RSP है, CS भी है।
नहीं CS नहीं है।
ये है, हम इसमें देखा
इसका ही ना corresponding CS खाता में। ये सारा
CS खाता नंबर 79 है, इसमें पेज 84 में देखा
18 है, CS खाता नंबर 79 है,
और उसका 18 इज RS खाता, CS खाता इज 79,
yes,
yes,
then
and then my lord may kindly see RS खाता 178,
this is the corresponding 18 का corresponding है 79,
हाँ 79,
and RS खाता का ये है
178, 177, 176,
और इसका कोई CS प्लॉट, इसका CS प्लॉट नंबर कहीं नहीं,
इसका CS प्लॉट नहीं, ये हमने इनको क्वेरी किया था, इसमें प्लान से भी हम पूछे थे। 35 के बाद से ये सब कोई यहाँ अभी फाइनली हुआ ही, वही तब चला।
CS खाता
CS तो 1908 में था, 35 में RS होगा, RS भी कंप्लीट नहीं हुआ, बंडा पर्चा ये सब इशू होते हैं रांची के एरिया। और जो शेड्यूल बी प्रॉपर्टी है, ये प्रॉपर्टी है ये है खेवट का प्रॉपर्टी है जो कि बुनियादी प्रॉपर्टी है, और बुनियादी प्रॉपर्टी तो बेस्ट होता नहीं है गवर्नमेंट में, मतलब ये तो इस पे जो सक्सेसर्स होते हैं उन्हीं का ही उनको भी राइट होता है।
What is the document of title so far as RS Khata number 178 is concerned? Is it recorded in the ancestors of yours? In whose name is it recorded? 178 किसके नाम से recorded?
बता।
And what is the evidence to that effect?
हाँ बता।
Because there is a finding that plaintiff has not brought any kit of paper
नहीं
to
नहीं
show
गलत लिख रहे हैं।
that at any point of time
नहीं गलत लिख रहे हैं।
he or his ancestor had title over RS Khata number 178.
हम बताते हैं।
Suit Khata number 177 is in the name of Buddhu Rao. The entire genealogical table given in the plain does not show Buddhu Rao.
नहीं हाँ वही वो भी एक पॉइंट हम बता रहे हैं वो सब क्या है कि वो सब बुनियादी लैंड्स है जिसमें हमारा स्पेसिफिक प्लीडिंग है कि वो सब डेथ कर गए। तो जब वो डेथ कर गए तो उसका जो खबरदार जो सर्वाइविंग खबरदार है उसी को होगा, क्योंकि गवर्नमेंट में तो डेथ होता नहीं। और वो चीज को भी नहीं समझे।
सर्वाइविंग खबरदार को कैसे जाएगा? सर्वाइविंग खबरदार किसको बोलते हैं?
सर्वाइविंग खबरदार ये इसलिए कर रहे हैं कि मान लीजिए जैसे बहुत सा फूट में जैसे एक जीनियोलॉजी को समझा जाए, हेला उराव के अलावा भी अगर उसमें
आपके ये सारे प्रॉपर्टीज में आपके किसी भी एंसेस्टर का नाम नहीं,
एंसेस्टर का नाम हम दिखा,
यही फाइंडिंग है। आप हमको दिखाइए कहाँ?
ये फाइंडिंग हुजूर एकदम बस फाइंडिंग है, मुझे को दिखा रहे हैं।
हाँ सर, वैसे
हम दिखा रहे हैं।
आपका
किस खाता के बारे में हमने किस
178 किसके नाम से रिकॉर्ड?
अभी बता।
The learned counsel for the appellant has submitted that the findings recorded by both the courts are perverse, and therefore the documents are required to be perused by this court. Let the records be called for from the concern. Perversity पे तो आपको बताना पड़ेगा ना, ऐसे perverse का finding आपके पहले से मंगाते हैं, records मंगाइए। Let the records at the special missing records to be submitted by the appellant within a period of 1 week from today. Post on 6th of November. Perversity का आप proper note बनाइए भाई, ऐसे हम कोई जजमेंट को परवर्स बोल के सब्सटैंशियल क्वेश्चन ऑफ लॉ इतना वेग नहीं बना सकते हैं। Each, you see, you have to prepare note in connection with each खाता number.
I agree.
The learned counsel has also submitted that numerous खाता numbers are involved in this case, and he shall prepare a note in connection with each खाता number to assist this court in the matter of framing of substantial question. हर एक खाता नंबर का कहानी बताइए, ऐसा थोड़ी है कि आपकी बात नहीं सुनेंगे।
नहीं,
क्लैरिटी नहीं होगा तो वेग क्वेश्चन ऑफ लॉ का क्या आंसर होगा?
इसका फैक्ट्स कुछ ऐसा है कि इसमें जो दोनों कोर्ट भी कंफ्यूज हो गए, और इसका फैक्ट्स ऐसा है अच्छा, लेकिन हमारे दिमाग में क्लैरिटी नहीं, हम बिल्कुल क्लैरिटी
तो उसको राइटिंग में
इसीलिए हम
उसका नोट बनाइए, ऐसे नहीं।
दिस मैटर रिक्वायर्स।
देखिए, अगर हमको परवर्सिटी नहीं समझ आएगा तो हम परवर्सिटी की बात होगी तो आई हैव टू रेफर कौन सा डॉक्यूमेंट से परवर्सिटी है, कौन सा एविडेंस से परवर्सिटी है। उसके बिना कोई
नहीं,
सब्सटैंशियल
इसमें
क्वेश्चन
जो-
ऑफ लॉ कैसे बने?
मेन पॉइंट हुजूर हम इसमें 2-3 पॉइंट जो उठाए हैं कि इसमें जो एग्नेटिक रिलेशन के बुनियाद पे जब हम क्लेम कर रहे हैं और इनको भी मान लीजिए अगर
जो
आप
भी आपको बनाना है आप इसमें
नहीं
कोड
बनाएं।
बनाइए, ये ऐसे नहीं हो सकता। It's not possible.
I will try to make मतलब better understanding बना लें।
From supplementary list for hearing on order 41/11, item Q, second appeal 532 of 2017.
Yeah, please. This is plaintiff second appeal. Again, the judgment of reversal. Plaintiffs filed suit for declaration of title and also for declaration of sale deed, which was executed by his predecessor in interest. The plaintiff
And also, he also challenged the
sale
sale
deed.
executed by his predecessor. Yes, then.
Now, kindly have a look to internal page 10 of the appellate. Suit was decreed in my favor. I was the plaintiff. Suit was decreed. Taking note of certain admitted facts regarding non-passing of entire consideration. Taking consideration of admitted fact of the defendant's case also, that yes, part of was paid, remaining was not paid. Now, my lord, appellate court and on interpretation of two documents. One document was regarding, my lord, the sale deed, for which I challenged the relief, sought the relief, my lord, and one exhibit which was produced by the defendant Safinama, that subsequent thereto we have paid the remaining balance consideration to the wife of the vendor.
Has the court recorded a finding that the entire consideration amount has been paid?
No. The learned appellate court has what has mannered. Learned appellate court has taken note of the recital of the sale deed, and there certainly mannered one judgment is against me, which is of the year 2009, which says that if the recital says that title passes soon after execution and registration of the sale deed, so title will pass to the purchaser, and so far as balance consideration amount is concerned, you go and file a suit for recovery of that amount. That is there. That is against me. Now, what my submission is that when there was two documents, my lord, the document which was exhibit A by 4 and one exhibit regarding which it has been claimed by the defendant that remaining amount has been
Sale deed is exhibit A by 4.
A by 21,385.
This Safinama is exhibit?
Exhibit C, my lord.
Exhibits.
This is dated 25.
But in spite of this Safinama, the appellate court has also not recorded any finding that the entire consideration was paid.
Yes, yes, that is there. So that
Then this Safinama becomes meaningless,
yes, unregistered document.
unregistered. Otherwise also it's because the court has not actually given a finding on the basis of
Exactly.
exhibits.
Yes.
Now what remains is the sale deed.
So now remains this exhibit. So there is one finding of one court in my favor while interpreting one sale deed and even accepted subpoena. The first appellate court reversed that finding. Now, my lord, I am relying upon the judgment reported in 2007 5 SCC para 17 that when any documentary evidence which goes to the root of the case, not root of the parties, it is a substantial question of law. It requires interpretation. Paragraph 17. One judgment also in 2019 I could not get it. Para 17.
So do you want to say that the sale deed has been misinterpreted?
Yes, Celdi and Safina.
Forget about Safina.
Yes.
Because the appellate court has not recorded a
Yes.
finding that the entire
Yes.
consideration
Yes,
has been
yes.
paid.
How many times doing?
You just
Yeah,
say
yes.
how
Yes,
the trial court has interpreted this
Yes, yes.
deed.
Now,
This
kindly
sale
take
deed.
my note. Well, I will show which is the finding which is against me, but because the appeal has been allowed, so I will refer first manner the appellate court so that I could substantiate my case. Manner, kindly take internal page 11 of the appellate court judgment manner, paragraph 9. This is admitted case. What the London first appellate court has recorded a finding. My lord, got it? My lord, kindly take point number Roman 4.
Yes.
Roman 4, my lord. This Roman 4 is, my lord, it is also admitted fact that as per the said CLT dated such and such, only 1000 rupees has been shown as paid. Now, a recent judgment of the Honorable Apex Court what says, my lord, that if, just showing, my lord, this is paragraph 38. Everything law will be clear, my lord. Paragraph 38. Just like on a similar factual background. Paragraph 38.
Yes.
Concurrent finding of both the first appellate court and the high court indicated that the husband of the defendant, that is one such and such, had allegedly given the remaining sale consideration of rupees 6,000 during the time of the execution of the sale deed. My case is at better footing. It is has been alleged by the defendant. I am not placing case of defendant that after execution and registration they have paid. Had not stepped into the witness was further one of the attesting witness to the execution of the sale deed that the Sarpanch had also died before his deposition could be recorded. One Puttu, who was the second attesting witness, was the brother of the defendant, and both the court had doubted this testimony as being partial to the defendant. And in all, there was no witness who could substantiate the case of the defendant that there was part payment of the sale consideration, that is rupees 6,000 during the time of the execution of the sale deed. Furthermore, no evidence was adduced by the defendant to prove that even the initial amount of rupees 9,000, which was purportedly paid before the execution of the sale deed, was actually received by the plaintiff. Therefore, after this is important, the averment of the plaintiff in the plain that she had not received the sale consideration had not been otherwise proven as false. In such circumstances, that is, in the absence of the sale consideration being tendered, the sale deed would be void. So once it has been admitted by defendant themselves that remaining balance consideration amount has not been paid, now my lord, the sale deed was void. And finding of the learned appellate court contrary to this, interpreting other factors is irrelevant. So this is the substantial question.
So the judgment of the 2009 is wrong.
नहीं, उसमें factual background दूसरा है. उसमें entire consideration amount was shown. Sometimes my lord, somewhat happened my lord in the sale deed.
And this provision of law which has been quoted by the learned first appellate court,
Yes,
that is also wrong.
No, provision of law is correct.
Then-
But in the facts of this case, when defendant himself admitted that remaining balance consideration amount has
It
not.
doesn't make any difference.
No, because if defendant says that balance consideration amount has not been paid, then AIA 2009 will not be applicable. But this is my submission. Then this decision will be applicable. And had it been minor, there was concurrent finding of both the courts, so the remaining consideration amount was paid, then I would have no case. So I, my lord, I have proposed I and J regarding Exhibit A by 4.
Exhibit A by 4 is simply stating that 1000 has been paid
Yes.
and the title passes.
No, that's why I referred my lord admitted case of the parties. This is the admitted case of the parties that no, 1000 was paid and remaining consideration amount was not paid.
That's right.
Yes. So this is not the case that in the sale deed rupees only 1000 has been retained and it has been paid. This is not the case.
No, the remaining consideration amount has not been paid.
Yes.
But therefore, under such circumstances, this particular provision of law, right, which has been referred to,
Well, that has been considered by the Honorable Apex Court in the decision report that I showed, my lord. Kindly take, my lord, page number, my lord, this one, page number internal, page number 29, section 54, my lord, kindly take, my lord. That has been considered that how, when a sale deed will be void, taking into consideration the provision of section 54.
just read it.
My
Roman
lord,
3.
the relevant provisions, observation are that.
No, ऊपर से पढ़िए Roman 3. Lastly, it was reiterated that. Okay, the
Yes.
relevant observation
Yes.
are.
Thus, section 54, sale defined. Sale is a transfer of ownership in exchange for a price paid or promised or part paid and part promised. Sale how made? Kindly see that. Such transfer in the case of tangible immovable property in the value of 100 rupees and upwards, or in the case of reversion or other intangible thing, can be made only by a registered instrument. In the case of tangible immovable property of a value less than 100 rupees, such transfer may be made either by a registered instrument or by delivery of the property. Delivery of tangible movable property is not applicable. Contract for sale. A contract for the sale of immovable property is a contract that the sale of such property shall take place in on terms settled between the parties. It does not itself create any interest or charge any property. Hence, a sale of an immovable property has to be for a price. The price may be payable in future, it may be partly paid, and the remaining part can be made payable in future. The payment of price is an essential part of a sale covered by section 54 of the Transfer of Property Act. If a sale deed in respect of an immovable property is executed without payment of price, and if it does not provide for the payment of price at a future date, it is not a sale at all in the eye of law. It is a
So
pure.
in the present case, the sale deed provided for the payment of the remaining consideration amount at a future date or not. If it provides, then it is not. Then the sale deed will not be void. But if it does not provide and says that the entire consideration amount has been paid, and actually it has not been paid, it will be void. And subsequent payment will not validate the sale deed. Correct? What is the sale deed here? Does it talk about future payment or it does not talk about future?
No, it does not. I will not say against the
Then-
defendant.
then
But yes, I will consider. So, sale deed, registered sale deed, the case of the defendant that it speaks about rupees 5,000. Kindly appreciate.
That's right.
Kindly appreciate. Now, yes. Now, therefore, the learned Supreme Court, Honorable Apex Court has said that yes, if part payment has been made and part after taking into consideration this provision 54,
Yes.
yes, that rupees 6,000 was paid and remaining was not paid. The defendant said no, we have already paid. So exactly similar is the case here. Now, in that case,
You just tell us.
Yes.
What is the consideration amount as recorded in the sale deed?
5,000.
5,000. Okay. How much was paid and
1,000.
recorded?
1,000.
1,000.
Admitted case. That's
What
why-
was anything mentioned about the remaining consideration amount?
regarding future when there is no.
Now there is 4,000 is the remaining consideration
Yes,
amount.
yes.
Was anything mentioned in the sale deed about the remaining consideration amount?
No,
Or it was silent?
it was silent.
From where do you say this? कहाँ से बोल रहे हो?
Yes, that's why I
From where do you say this?
From-
Where is the sale deed?
yes,
You must have gone through the sale deed to
Yes,
make this
yes,
submission.
that's why, yes.
Where is it?
yes.
Show me the sale deed.
Well, because I am arguing against me, that's why I am saying. Second page में my lord will find regarding
कहाँ लिखा है कि बाकी के पैसे के
नहीं
बारे
नहीं
में?
है वही तो बताएं कि it is not written that is silent and one line is against me I am showing my lord against me that they say कि वो म्यूटेशन करा लेंगे हस्तांतरित कर देंगे these things are but these are the format of sale deed what I am
Yes.
saying.
The learned counsel for the applicant submits that in the present case, the sale deed exhibit
A by 4
A by 4 has been wrongly interpreted by the court, and the learned first appellate court has wrongly relied upon the provision of section 55(4) of the Transfer of Property Act to hold that the remaining consideration amount could be realized by taking appropriate steps, and if part payment is made, then the same deed and the property is otherwise transferred by registered deed, the same would not make the sale deed void. That's it.
Right.
The learned counsel has relied upon the judgment passed by the Honorable Supreme Court, reported in passed in the case of Civil Appeal number 11795 of 2025, in the case of Shanti Devi, since deceased versus Jagan Devi, decided on 12th of September 2025, and has
para 38
referred to para 34 of the said judgment, wherein the principle of law has been mentioned that by principle of law by referring to section 54 of Transfer of Property Act has been mentioned, by observing that the payment of price is an essential part of a sale covered by section 54 of the Transfer of Property Act. And if a sale deed in respect of a removed property is executed without payment of price, and it does not provide for the payment of price at a future date, it is not a sale at all in the eyes of law, and it has no legal effect. The learned counsel submits that in the present case, the price of the property was mentioned as 5,000 rupees, and only 1,000 rupees was paid at the time of execution of sale deed, but there was no mention that the remaining amount will be paid at a future date. Consequently, the title cannot be said to have passed by virtue of the sale deed. He submits that the learned courts have wrongly, the learned first appellate court has, while reversing the judgment of the learned trial court, has wrongly interpreted the sale deed exhibit 4 by
A by 4.
A by 4. Considering the aforesaid submissions, this appeal will be heard on the following substantial question of law: whether the learned first appellate court heard in interpreting the sale deed exhibit A by 4 by applying the provision of section 54 of the Transfer of Property Act.
Deeply.
Issue notice to the respondents for which requisites under ordinary process as well as pre-post be filed within a period of 1 week from today. Let the records be called for from the concerned court. Office to tracks post delivery. Post this case on 3rd of
Deeply.
ये आप ले लीजिए वापस और ये जजमेंट
Smile.
इसको लगा दीजिए सर, टैग करा दीजिएगा नहीं तो बाद में गुम हो जाएगा।
Item 3, second appeal.
जब लगे कि कोर्ट हॉस्टाइल है तो आदमी अच्छा प्रिपेयर करता है,
Yes.
राइट?
Grateful.
यस्टरडे कल ही हुआ था।
Yes.
आज आप प्रिपेयर करके आए हैं तो आपका बन गया सब्सटेंशियल क्वेश्चन ऑफ लॉ।
Item 3, second appeal 22 of 2020.
यस मैडम।
My senior had made submissions on the.
Yesterday I am not able. You are yes. What is it? You were under license.
Yes,
The license expired.
there is no expiry date of the. I had purchased the property from the original allotting ownership.
The allottee was having the license.
Yes, Your Worship.
So what you
And that
purchased
is
is only the
as
license.
defendant also.
What you purchased was only the license, right?
Yes, Your Worship. I am not claiming ownership or title, Your Worship. That is why I am not even asked for declaration of title. Your
What was
Worship.
the suit for?
The suit was for perpetual injunction and recovery of possession, Your Worship.
Perpetual injunction and recovery of possession.
Possession, Your Worship.
You were not in possession.
I was dispossessed during the pendency of the suit, Your Worship. The defendant had
But you have not prayed for confirmation of possession.
No, Your Worship. I
Why?
asked for recovery.
If you were dispossessed during the pendency of the suit, you have not made that alternative relief. That prayer has not been made by you.
But Your Worship, this prayer of recovery had been added later on, Your Worship, because the defendant are the allottees of the adjoining shops, Your Worship. My shop was burned, Your Worship, in 2002, Your Worship. When I tried to repair the shop, at that time they installed a shutter and they amalgamated both the shops, Your Worship.
It was
And I was
just
outside, Your
simply a suit for injunction.
Injunction, Your Worship, and recovery of possession, Your Worship. My possession has been since 1969, Your Worship. It has not been disputed by the defendant also. They have also
You
admitted
took it from whom?
from Abdul Rahman, Your Worship.
When?
In the year 1975, Your Worship.
So how is
I
your
was
possession?
but I was in possession. I was in possession as a tenant, Your Worship, subtenant, Your Worship, of Abdul Rahman, Your Worship. Abdul Rahman, in the meantime, had mortgaged the property to the ancestor of the defendant, Your Worship. Sheikh Jha, Your Worship. And later on, there was a settlement with the plaintiff purchased the property and then he paid off the mortgage amount also, Your Worship. I have written in my plaint, Your Worship, that I was paying rent to Tisco, Your Worship.
Rent to whom?
Tisco, Your Worship. I have written in my plaint, Your Worship. This has come.
What is the evidence? You are writing in the. If you have paid, you have to show us
Your
that
Worship,
you have paid.
possessory right word has not been mentioned in the plaint, Your Worship.
You see, you are seeking a declaration of You are seeking injunction,
Injunction, Your Lordship.
right? So you are not seeking a declaration of your. You are on the basis of your possessory right, right? Even that declaration you have not sought for.
I
In a
have
case-
sought for declaration also, but there was an issue framed in the lower court based on my pleadings, Your Lordship. The issue number 5, Your Lordship, in the title suit was whether the plaintiff has got possessory right and interest over the suit shop, which was decided in my favor, Your Lordship. I have renewed my trade tax license also in the year 2002-2003, Your
That is
Lordship.
not binding on the respondent.
Just to show Your Lordship that I have been.
The admitted facts in the trial court judgment is that suit number 95,
Yes, shop number.
the shop number, was allotted to Abdul Rahman.
Yes, Your Lordship.
The shop was burnt twice,
Yes, Your Lordship.
1992 and secondly in 2002. Right. What are the issues framed?
Your Lordship, page number 44 of the memo.
What is the finding in connection with maintainability of the suit? Yes. 1, 2 and 3, what is the finding?
Your Lordship, regarding issue number 1.
1, 2 and 3.
Your Lordship, para number 8 of the title suit, Your Lordship, page number 53. Issue number 3 and 4, it says that the issue were also framed on behalf of the defendant. However, during the trial and argument, these issues have not been pressed by either side, therefore these issues are decided in negative. And regarding maintainability, Your Lordship, since the issue number 7 has been decided in favor of the plaintiff and he has been found entitled to a decree for recovery of possession of the suit shop from the defendant, therefore the plaintiff has got valid cause of action to sue the suit and the suit is maintainable in its present form. Hence, both these issues are accordingly decided in favor of the plaintiff. Your Lordship, issue number 7 was if the plaintiff is entitled for recovery of possession.
When was the suit filed?
In 2003, Your Lordship. February 2003, Your Lordship.
The trial court has reversed
The appellate court.
The appellate
court. Yes, Your Lordship.
on what ground?
On the ground that these two are, both the prayers are contrary to each other, the claim cannot be.
Where is the finding?
The finding starts at page 72, Your Lordship.
Where is the evidence?
Peruse the evidence.
Details.
Peruse the evidence on record. PW1 has proved the carbon copy of Sakshi Police Station SD number 836 dated 24 April 2002, which has been marked as Exhibit 4 with objection. This witness has also proved the photocopy of the same dated 7th October 2002 and it has been marked as Exhibit 7 with objection. He has also proved the money receipt dated 21st September 2002 of the money paid to Gulam Sarwar, which has been marked as Exhibit 8 with objection. He has also proved the money receipt dated 4th May 1975 regarding the sale of shop number 95 Teen Shed Tank Road, Sakshi by Moinuddin, and got it. Moinuddin is the son of late Abdul Rahman, and got it marked as Exhibit 8A with objection. He has further deposed in his examination
So
that
he sold it.
yes, Your Lordship. Sold it
To
to
you?
the plaintiff. Yes, Your Lordship.
Then
He has further deposed in his examination that on Exhibit 4 there are signatures of 15 persons whose shop was burnt out of 42 persons and he has signed at serial number 9. He has also deposed that it has been mentioned in the Exhibit 4 that the papers of the suit shop have burnt. He received the photocopy of Exhibit 7 from the police station but it was not copied in his presence. Therefore, he cannot say that whether the Exhibit 7 is a forged and genuine document. He has again deposed that Exhibit 7 is a forged and no such deed was prepared. Exhibit 7 is a photocopy of the photocopy. PW,
You come to next page, bottom.
Your Lordship, I'll just read out DW1, Your Lordship, the third paragraph. DW1 is the defendant of this suit. He has deposed in para 29. He has stated that he has not made his signature as the purchaser when the photocopy of sale dated 7 October 2002 was shown to him, but by the learned counsel of the plaintiff. In para 36, it is true that prior to 1989, plaintiff was in possession of the suit. I'll read after the defendant. In this suit, issue was framed on 27th April 2009 and further issue was recast by the learned trial court on 1st July 2014. So far possessory right is concerned, this court is of the view that pleading includes plain and written statement and issues were framed on the basis of the pleading. Learned lower court has travelled beyond the scope of the pleading of the parties and decided issue number 5 in favour of the plaintiff. Nobody raised possessory right in his pleading. Plaintiff has not sought any relief regarding declaration of possessory right, but on averment in the evidence, learned trial court has framed this issue. In para 13 of DW1 stated that that the suit shop was allotted to Abdul Rahman by Tata Company Limited, and during his lifetime, Abdul Rahman has been in possession of the same, and after his death, his successors came into the possession of the suit shop. The plaintiff was given the possession of the suit shop in the year 1989 as licensee by the successors of Abdul Rahman. Perused Exhibit 4, it is clear that plaintiff and defendant both have signed on same application on Sana number 836 dated 24th April 2002, which is the information given to the Sakchi police station. This document shows that Gopal Jha is in possession of shop number. Gopal Jha is the defendant, Your Lordship. Gopal Jha is in possession of shop number 93 and Noor Mohammed is in possession of shop number 95. Perused Exhibit 2, 2A, 3 and Exhibit 3A shows the plaintiff made complaint SSP Jamshedpur regarding his dispossession from the suit shop. Perused the Exhibit 7, which is photocopy of sale date executed between heirs of Abdul Rahman and Gopal Jha. Exhibit D, which is filed by the defendant, which show that agreement of mortgage was executed between heirs of Abdul Rahman and Gopal Jha on 18 July 1997. Exhibit 8 is money receipts, which show that Ghulam Sarwar has written this money receipts with son of Noor Muhammad. Exhibit 8A is the money receipt written by Israel Haq and signed by Sheikh Jha.
In the case of injunction, how the court will enter into this kind of a dispute? Not in a suit for injunction. In a suit for injunction, you have to especially show your title. There is so much of conflicts, and therefore the plea that you have not raised has rightly been taken care of.
Plea has not been raised. The word has not been used, Your Lordship. The plaint has
No. This is not the scope of injunction.
Your Lordship, the plaint has
This is not the scope of injunction.
Your Lordship, the plaint has been read as a whole. We have admitted again and again that we have been paying the rent Tata Steel, Your Lordship.
No.
And title we
So if you are paying the rent to Tata Steel, whenever they file an eviction suit against you, you take care of it. You use that rent receipt.
But the defendant has been illegally trying to evict me, Your Lordship. They have entered, when there was fire, Your Lordship, they have entered into the possession of my shop forcefully, Your Lordship. This has come on record, Your Lordship. The the report that we had submitted, Your Lordship, contained both my signature as in possession of shop number 95, Your Lordship, and him as possession of 93, Your Lordship. I was all along in possession, Your Lordship, before the fire had taken place, Your Lordship.
Even TISCO has not been made a party.
No, Your Lordship, TISCO has not been made a party.
They are necessary party.
Halfway, Your Lordship, had been held that they don't need to be made
No,
party.
they are necessary party. The appellate court has taken care
No,
of
Your Lordship, they have. Your Lordship, in page 60,
that. It is barred by section 34 also.
34, Your Lordship.
Yes, it has certainly gone beyond the scope of the pleadings of the party and beyond the scope of the injunction application also. An injunction application cannot decide the title of the parties. It just can't.
But Your Lordship, my possession.
Essay number 22 of 2022.
My possession was decided, Your Lordship. It was in my possession all along, Your Lordship.
Be happy with your possession.
I have been evicted not by the licensor, Your Lordship. by
You-
third party, Your Lordship.
You get your title declared.
I'm not asking for declaration.
No,
of
whatever
title
be the
because
nature of title, it may be possessory right is also a title.
this is the issue that has to be. This could be the
This
question
such
of
kind
lawyer.
of things cannot be decided in an injunction petition. It just can't be said. Injunction doesn't work in this manner. Even for it is kind of you're seeking a declaration of the title, maybe possessory right. Possession is more than the title actually. A person in possession is a huge right.
Your Lordship, the appellate court has gone
Essay
to
number-
technical terms,
That's
Your Lordship.
Essay number 22 of 2020. Heard the learned counsel for the appellant.
My
This
question
appeal has
of
been
law
filed
needs to see, Your Lordship.
against judgment dated 27/9/2019 with the decree signed on 18/11/2019, passed by learned District Judge Roman 9 Jamshedpur in civil appeal number 20 of 2015, whereby the learned District Judge has allowed the civil appeal preferred by the defendant. The title suit was decided by judgment dated 23/2015 with the decree signed on 27/3/2015. Injunction ये एरा 2 सपोर्ट करेंगे appellate court का prayer quoted is. The learned counsel for the appellant has submitted that during the pendency of the suit, the plaintiff was evicted by the at the instance of the defendant, and therefore a prayer was also made for recovery of possession. The learned counsel has submitted that the learned trial court had declared by decreeing the suit held that the yes, held that the plaintiff that the plaintiff was dispossessed by the defendant on 22/3/2003 from the suit shop, and the plaintiff has got possessory right and interest over the suit shop. However, so far as the learned first appellate court is concerned, the appellate court has reversed the finding by holding that the suit was decided beyond the pleadings, and also by observing that the plaintiff of the suit has not filed any claim seeking declaration of his title or right, and therefore the suit was barred under section 34 of the Specific Relief Act. It was also held that it was admitted fact that the learned trial court had gone beyond the scope of the pleadings of the parties. The learned counsel for the appellant, while assailing the judgment passed by the learned first appellate court, has submitted that the plaint was required to be read as a whole, and the finding of the court that the plaintiff did not claim that nobody raised the plea of possessory right is not in accordance with law. This court finds that the suit was filed seeking injunction perpetual injunction and also for recovery of possession. The learned first appellate court has also recorded that the suit was not filed, the plaintiff did not file the suit. The plaintiff in the suit did not claim any declaration of his title or right, and therefore the suit was barred under Section 34 of the Specific Relief Act. Apart from that, the learned first appellate court also recorded that no specific plea was raised with regard to possessory right, nor any relief was sought for declaration of possessory right, but only on the averment of evidence the learned trial court had framed the issue. This court finds no error in the judgment passed by the learned first appellate court, and accordingly the appeal, no substantial question of law arises, and accordingly this appeal is dismissed. You have to seek a declaration of your title.
Not required. That's what I'm. There is direct Supreme Court judgment on this point. 2021. That is no.
We have seen
Your
it.
Lordship, Your Lordship may not interfere with this order, but generally the law is that if I am not disputing the title of the defendant, then a suit for injunction simplicity is maintainable. V. Ramakrishnan Reddy versus M. Malappa.
That's it. We have seen that.
That's what I'm saying. So here I am not
There-
disputing.
It is. That's right. There is some obligation. It is your right was required to be declared. Otherwise, you are absolutely a third party in possession.
But my possession was admitted. Even if I encroacher, I am in possession, settled possession. I can't be evicted because there is a fire in the soaked property. That is Your Lordship should consider.
Justice.
From daily follow Wikipedia item 9, second appeal, there was 3-4 of 2018. Am I
Thanks. You can now have them. Saurabh? Mr. Eviction सिन्हा का नाम डाल देंगे appearance में. What is it? Louder से किसके आए? Where are the parties? इसका हमने notice issue कर दिया. अभी तो yes madam, your case has been called out. What happened to this?
We find IA
constitutional limitation. But this substitution petition is also defective. The names you have seen the report. You see the office now. The spelling is incorrect. Parvati, but Parvatiya, Devi in memo of appeal. Safina Devi in the memo of appeal, it is, you just have a look at it, your IA is defective.
Password for my Your Worship, I may be permitted to correct it during the
Essay
course of
number 334 of 2018. Counsel for the applicant is present, who submits that a petition for substitution has been filed with respect to respond number 1, 5 and 12. But as per office note, there are certain typographical error in the name. She submits that she may be permitted to make necessary correction. It will be done by the counsel for the applicant in writing to the court secretary. Right. They have pointed out all the difference. Issue notice to the proposed legal heirs and successors of respond number 1, 5 and 12 for which requisites in the कहाँ के सब लोग झारखंड
this Worship.
ऑल दुमका
All of them are from the Worship.
for which notice we filed through speed post. And also ordinary process. You file ordinary process. The in the IA number 13027 of 25, a copy of the mediation report based is happening.
Yes, Your Worship.
A copy of the mediation report
Your Worship, mediation report has not been sent.
as forwarded by the as forwarded by the High Court Legal Services Committee. We also sent along with the notice. At this, the learned counsel for the applicant has submitted that the proposed legal heirs and successors had attended the mediation proceedings and they are extremely poor persons. In that case, it will certainly be open to the proposed legal heirs and successors to take legal aid through the Jharkhand Legal Services. Or if they appear before this court, then legal aid can also be provided by appointing an amicus curiae. Legal aid can also be provided by the orders of this court. तो बहुत टाइम लग जाएगा इसमें. Post on 6 November awaiting service.
Requisites के लिए कितना टाइम होगा?
Requisites के लिए 1 week prior to vacation you file.
We have to file a copy of the mediation report.
No, the office will send it. Office is that will send it. ये दे दीजिए ना. ये mediation report ऐसे देना ठीक है.
Yesterday I just wanted to confirm the Worship. Mediation report, I don't have to copy with the requisites they asked.
Have you mentioned in your IA that it has been settled in mediation?
Yes, Worship.
सिर्फ IA पर नोटिस करेंगे. mediation report नहीं देंगे. आप IA पर नोटिस करेंगे. By next Thursday.
Yes.
You correct it, please.
Order Saturn 10, second appeal 254 of 1020.
Ladies, there are various parties in this case.
resume. Some of them want to compromise. So
Some of them say compromise.
they are negotiating leadership. So time may be given.
Who are negotiating?
Sorry.
Then I'll send it to child suffer mediation.
No, actually, they have said to wait for till DP so that
This is
all
not.
the parties.
I'll send it for mediation. अब वही पे जाके सबमिट।
No, but only for
दोनों चीज नहीं चलेगा। टाइम लेने के लिए मीडिएशन चल रहा है, सब कहानी में चलेगा।
no, let's say that is not the case. But only since they only for a week they have said.
If you say that they are already negotiating, I'll send it for transfer. It will
Then-
expedite.
Then time may be given, but so only for a week.
Time for what?
So that latest status they can communicate.
अभी तो सब्स्टिट्यूशन भी बाकी है।
Yes, that's,
सब्स्टिट्यूशन जब तक नहीं होगा तब तक क्या मीडिएशन है?
that's what they are saying.
नोटिस हुआ? Essay number 254 of 2020. As per the service report, respondent number 1A to 1E, who are the legal heirs and successors of respondent number 1, have been served either by themselves or through their close relation who are already on record. Who are already on record, either through the close relations. Accordingly, the service of notice upon respondent number 1A to 1E is accepted as valid. When did she die? कब हुआ death?
During pregnancy.
When? When did she die? Date of death बताइए.
2023.
Where is it mentioned? The learned counsel for the appellant has submitted that IA number 5208 has been filed seeking substitution of respondent number 1, who has expired on 27/10/2023. He submits that a petition for substitution was filed at the stage when the second appeal was pending for restoration, as it was earlier dismissed for default, and in the same proceedings the substitution of the present respondent number 1 was allowed after condoning the delay. He submits that the substitution be allowed, considering the aforesaid submissions. The IA number 5208 of 2025 is hereby allowed. Counsel for the appellant is directed to delete the name of the respondent number 1 from the cause title and insert the name of legal peers and successors whose details have been mentioned in the eligibility application at paragraph number 3 in writing during the course of the day. Substitution भी बनाने नहीं आता है, setting aside amendment, limitation, exception. So एकदम ही bankruptcy का स्थिति में पहुंच गए, कुछ प्रयत्न कुछ नहीं कर दे रहे, आपका हो गया. Just imagine where you are.
Then we will file something.
इतना मैकेनिकल तरीके से आप सिविल लिटिगेशन नहीं हैंडल कर सकते. Now you want time.
Only for a week.
The council has submitted that the parties are likely to settle the dispute out of court. He submits that the matter be adjourned for a week, post on next Thursday.
Item 11, second appeal 119 of 2022.
In this case, by order dated 9/9/2025, the notices in respect of respondent number 6 and 7 have been accepted to be valid. So far, respondent number 1 to 5, which were found to be valid not previously, that is the office note.
So why
So
is
far, respondent number 8 is concerned. Respondent number 5, the substitution was directed to be taken. The step for substitution was directed to be taken. Now it is in the process. Not that today the affidavit has been sworn and it will be filed not tomorrow itself. There are not 8, 7 respondents. 8 respondents.
Substitution किसका फाइल करना है?
8. Poonam Devi.
The learned counsel for the applicant
Today itself
has
it is
submitted
in
that
process.
has praised for time,
We will still next Thursday.
post on next Thursday.